Mr. Connolly.
Thank you, Mr. Chairman. Mr. Horwitz, to pick up on our colleague, Mr. Jordan's questioning, he was concerned about Ms. Bosserman's political history, correct?
That was the question.
Did I understand you to share his concern?
I know nothing about the facts involving the matter other than what I've read in the newspaper, so I'm not opining on this issue.
As an IG in general, would it concern you that the FBI might employ the services of somebody who has a particular expressed political predilection in the form of a campaign contribution?
I think the hypothetical question for us is dangerous to get into, and I think respectfully defer.
Well, let me move beyond the hypothetical. First of all, for the record, there's a letter dated October 31 to the chairman, Mr. Issa, from Stephen Kelly, pointing out that there are 11 special agents assigned to this particular case, not one. And Ms. Bosserman's one of 11. Is that a fact?
I have no idea.
Are you familiar with this letter from Mr. Kelly?
I'm not.
Well, presumably, since it's an official letter on Justice Department, it's not subject to dispute. He did, in fact, write.
I'm not disputing it. I'm just,
All right,
I haven't read.
The gentleman would say that if the Justice Department says something, it must be true.
You know, I'll hold that in advance, Mr. Chairman, but I would ask without objection, Mr. Chairman, that letter be entered.
Without objection.
I thank the Chair. Secondly, Mr. Horwitz, also beyond the hypothetical, let me read to you a statement from the Department of Justice spokesperson with respect to Ms. Bosserman, this very issue. Quote, "It is contrary to department policy and a prohibited personnel practice under federal law to consider the political affiliation of career employees or other non-merit factors in making personnel decisions." That is a statement from the spokesperson of your department. Do you in any way challenge that statement?
I have no information to challenge.
You don't have any information about what the law requires?
Generally, I would accept that as a proposition.
Right. It's actually against the law to ask somebody their political affiliation when you're meeting out assignments in your department. Is that not a matter of,
Correct.
of record? Yeah.
We would not do that.
Right. So if we actually did what Mr. Jordan seemed to be suggesting, it would actually be a violation of law by superiors in the Department of Justice.
My understanding, the law generally would prohibit asking the question.
I thank you, Mr.
Would the gentleman yield?
Is Mr. Jordan? Yes, Mr. Jordan, I would yield.
The way I read this, I think the way it's understood, employees' participation in a criminal investigation should not create an appearance of conflict. It's the lawyer's obligation to make that known. We just happened to find it out. They didn't tell us. We just found it out. We found out from other witnesses who said it's her responsibility.
Reclaiming my time.
That's why it's appropriate.
Reclaiming my time, Mr. Chairman. I respect my friend's point of view, and therefore I know he can relate to the consternation many of us on this side of the aisle felt when we learned about the political contributions of Mr. Russell George, and wondered whether that might color his testimony before.
Would the gentleman yield again?
No, I'm running out of time. Otherwise,
point.
I'd be glad to. But it just seems to me, if we're going to make an issue out of someone's political giving, then let's make an issue out of someone's political giving and address it in legislation. But it seems to me, and Mr. Horwitz has just testified under oath, that it is his also concurring opinion that it would be a violation of law to do what you suggested or seem to be suggesting the Department of Justice ought to have done. Ms. Gustafson, how does an IG investigation get before SIGI? If someone says, I think Harry Houdini has done something wrong or violated ethics or whatever it may be, how does it get before SIGI?
And in this instance, Harry Houdini is an IG. Is that what we're talking about? How do we?
Or Harriet Houdini.
Yeah.
Either one.
Well, the reason I asked
is this a disappearing question?
I'm trying to understand your process, because there is a case that from the archives that's still pending before, and it's taken an awful long time.
Right. So the IG Reform Act of 2008 statutorily created the Integrity Committee, which is a standing committee of SIGI, which does investigate allegations against an inspector general. So the way that those allegations would be conveyed to the Integrity Committee there are several ways. They have their own email, they have an address. If it comes through other matters, which is to say if it somehow reaches the chair of SIGI, who's Phyllis Fong, she's the IG of Agriculture, she would convey those to the Integrity Committee. That's a standing committee that then undertakes their process for investigating.
Excuse me for interrupting 1 second. Mr. Chairman, Mr. Jordan, when he was in the chair, promised us a little bit more time. Would the chair indulge me with another 20 or 30 seconds?
You're at 24, and you're on a roll. All
right,
just keep going.
I just have one quick follow-up,
Of
and then
course.
I won't abuse it. I thank the chair. Sorry, Ms. Gustafson.
So the Integrity Committee is a standing committee. There's a representative from the FBI. There are 4 IGs on that committee, Office of Special Counsels on there. They determine whether the allegations warrant an
Has
investigation.
Merit. But because I am running out of time, and I do not wish to abuse the indulgence of both chairs, can an outside party come to you and say, I think Harriet or Harry Houdini has...
Oh, absolutely. Anybody can come
Okay.
with allegations.
Good to know.
against an IG.
Thank you.
Everybody has standing.
Thank you, Mr. Chairman.
If I could beg the indulgence of the gentleman, just because of something that Mr. Horowitz said, in the case of an attorney who may have a perceived conflict or an integrity question, although Mr. Connolly asked you the question, my understanding is in your earlier testimony that clearly this is where it doesn't go to you. The question of the gentlelady, Ms. Boswell, it's not going to come to you. It's going to go to the Office of Professional Responsibility.
That issue arises and would actually trigger the concern Congressman Cooper raised about the potential that we would both think we might have jurisdiction and create overlapping issues.
Mr. Chairman?
It does demonstrate that problem.
Briefly.
My understanding, based on Mr. Horowitz's opening statement, it's in a lawyer's capacity as a lawyer. Their conduct in the courtroom, their conduct as a lawyer that goes to OPR. Anything else, whether they get the case, how they're assigned the case, professional misconduct, not recusing themselves like they should, that is all under the Inspector General. It's just their advice as a lawyer, how they, that's where OPR comes in. Is that correct?
Can I just...
You know, I know we just sent a letter, and I'm well aware. I just wanted to make sure that Mr. Horowitz had the situation that I think is going to occur, which is in the question of public integrity related to whether or not she should have disclosed and or recused herself. I strongly suspect that this will be a test for Mr. Cummings and myself of how it is handled, because it's a valid question that's been raised. There are 2 possibilities for who will look at it and how it will be interpreted. And as we look forward to proposed reform, I quite frankly, with Mr. Connolly, Mr. Cooper, and Mr. Jordan, I'm looking forward to see how the investigation, the decision, the process is, because we're here considering a significant legislative action that would clarify any areas of ambiguity, and you brought one up. So I wasn't predicting that there was an authority. Just the opposite. I think this is a good test case. Okay, we now go to the gentleman from South Carolina, Mr. Gowdy, a man who knows about public integrity and what a lawyer should or shouldn't do.
Thank you, Mr. Chairman. Mr. Horowitz, you did a wonderful job with Fast and Furious. You told us that you would be fair and even-handed, and you were. I want to talk about one thing that bothers you, one thing that bothers me, and then one thing that you're too smart to answer, but I want to talk about anyway. What bothers me is when agencies come in here and there's an allegation of criminal conduct, and they have to wait until the Inspector General investigates it before they can stop the criminal conduct. Because my understanding was that you actually don't investigate and prosecute criminal conduct. I don't think you have access to a grand jury, do you?
We don't have, we investigate, but we can't make the prosecution decision.
Can you indict?
We cannot.
Can you prosecute?
We cannot.
Can you recommend sentences?
Nope.
If someone at the Department of Justice were watching an employee raid the vending machine, should they stop it, call the police, or call you?
Probably all 3.
Yes, they should stop it. I mean, they don't need to wait for you to tell them to stop a criminal act, which is why I'm so frustrated with the IRS, the notion that all they have to do is just refer it to the Inspector General, and they have no duty at all to investigate on their own, no duty to stop the conduct, just turn it over to the Inspector General, and that kind of tolls their moral statute of limitations. All right, I want to talk about what bothers you. You are a really, really good lawyer. I can't afford your hourly rate, but I'm going to ask you anyway to put your hat on as a lawyer. What is the argument on the other side for not allowing you to do what OPR does?
The argument traditionally has been OPR has the expertise to deal with ethics issues, understands some of the more difficult issues within the bar rules and the various state bar rules. There are 50 state bars, differing rules, and that expertise shouldn't be usurped.
All right, your background, you were in the Southern District, you were in Main Justice. I assume to be the Inspector General for the Department of Justice, you have to have a pretty similar background. You have to be an attorney, I would think, don't you?
Traditionally, that has been the case. Certainly the last 3 IGs have been lawyers.
Do you think that's why they were reluctant to give the jurisdiction for OPR to the Inspector General, because you may have a non-lawyer as the Inspector General, or you may have someone that doesn't have a background in criminal prosecution?
I think that it was one of the concerns at the outset, back in the late 80s.
All right. I picked up from my friend from Virginia and my good friend from Ohio that you're probably not, wisely not going to weigh in. But I do want to ask you just some questions, not about this in particular. I want you to tell the committee what a strike for cause is. You're back in a courtroom in the Southern District, and what's a strike for cause?
As you're doing voir dire, which is jury selection, each of the parties, prosecutor, defendant in a criminal case, plaintiff, defendant in a civil case, has the right to strike for cause jurors. The judge ultimately decides whether to accept that, but the strike for cause is that that individual can't fairly judge the case for some particular reason, either unique to the individual or to the case.
And do you also have other kinds of strikes that you can use when you are drawing a jury?
You have then peremptory challenges where you don't need to explain a cause for the strike, but
It just can't violate the law, Batson. Right.
You can't do
but
it
you get
for-
to decide whether or not you think that particular juror could be fair.
Right.
And in reality, I suppose my mom could be fair in judging my conduct. She could be. But there's no way in the world you would ever seat her on a jury.
I probably would.
No, you would not. And
Let's not use something,
I wouldn't seat your mom on a jury. She could be fair. I don't know Miss Bosserman. I've never met her. The fact that you donate money to a candidate does not de facto mean you cannot be fair. But I can't help but think, in an investigation this politically charged, you can't find someone at the Department of Justice that doesn't have this background. You and I both work with people that would never donate money to any candidate. They're just apolitical. They're career prosecutors. They're not wanting to be the U.S. attorney. They're not wanting to be a federal judge, so they're not going to donate money to senators. They're just career prosecutors. For the life of me, I just don't understand why you wouldn't pick someone so we don't have this conversation. You spent a large portion of your career being concerned about the result, but you also spent an equal amount of your career being concerned about the process. I don't know whether Ms. Bosserman can be fair or not. I will just say this. It was an unforced error on the process side, and I don't understand why they did it, Mr. Chairman.
I thank the gentleman. I might note for the record that no one ever found me guilty more often than my mother. We now go to the gentlelady from Illinois, Ms. Kelly.
Thank you, Mr. Chair, and welcome to the witnesses. Ms. Gustafson and Mr. Horowitz, I have a few questions about budget cuts on your IG operations. You both, whether today in testimony or in prior hearings, talked about hiring freezes and your staffing levels. So I wanted to know, are your staffing levels still below the levels they were prior to the budget cuts?
My staffing levels, haven't changed, as every agency is. I was waiting with bated breath to see, and still am until it's enacted, what my budget will be for this year. So I have had a hiring freeze now for a couple of years, and I remain 17% below. And that tends to be, just given attrition, it's almost all in audit. My audit staff is drastically low right now.
And we are still far below where we were when I was sworn in April 2012. I am very hopeful after seeing the proposed legislation that we will get that budget and be able to move forward, because that will help considerably.
And Ms. Gustafson, if the hiring freeze remains in place and you cannot fill your vacancies, what impact will that have on your ability to oversee the Small Business Administration?
Well, there's no question, again, my vacancies are in audit, that the amount of audit work that we can do, both in the 7A and the business lending programs, which is $750 billion portfolio, and then 23% of all government contracts are small business contracts, and our oversight of that is going to be slower. I mean, we're going to be having less oversight until I can come back up to speed.
Okay. And have there been cuts in your travel budget or any other of your budgets, and what have the consequences been of these cuts?
I have been lucky in that I have not had to restrict travel of my investigators. Most of my travel budget comes from my criminal investigators. I only have about 40 of them to cover the entire country. I will tell you that I know that there are some IGs that have restricted travel of criminal investigators, where if the allegation is in Omaha, they haven't had the money to go to Omaha to look for those crimes. I have not had to do that because I'm down so many people, unfortunately. So.
Okay. So it does impede the ability to investigate without having enough resources.
Right.
In.
Right.
Okay. Even though you both seem helpful, but if their flat budgets going forward would prevent further reductions, but also prevent your office from growing back to their pre-cut levels, what would the consequences of this type of funding be on your audit programs in the coming years?
Well, I would remain at some of the lowest levels that I've been in some time, again, because even stagnant, some of my auditors, they will, as they mature, as they get more experience, they've gone up in grade, and so in order to absorb and be able to not have to do furloughs, we've had to keep those vacancies, and that would have to stay. So.
Okay. And for any of you, what were the consequences of the government shutdown on your offices?
We stopped working for 16 days, my audit staff and my investigative staff, unless they had criminal cases going on or grand jury appearances, things that on a case-by-case basis absolutely needed to be done, were time sensitive. They were home. The taxpayers weren't getting anything. They were home. So.
The same here. Other than our investigators who were at work, our audit staff was completely at home, and all of our investigations, as a result, were shut down during that. Our audits were shut down during that period.
Thank you.
It was the same at the Peace Corps OIG, only the investigators work, and we had congressionally mandated work that was due in November that we couldn't do, that we were hoping to get done.
Thank you, and I yield back. Yeah, yes, I will.
Thank you very much. Let me ask you this. Yesterday I was at an event in Social Security in my district. We have probably the largest number of Social Security folks because we're headquarters. And we were dedicating a building, and I had a chance to talk to some of the employees afterwards. And one of the things that they were telling me is over the last 3 years, they've lost 11,000 employees. But they talked about the morale. Mm-hmm. And you can't put a dollar sign on that. But they were talking about how they were now having to do a lot more work with a lot less people, and that they felt that they were not being efficient. And so I'm just wondering, how does it affect morale? And, what kind of slippery slope are we going down here? You may not agree with that, but go ahead.
No, I think that there's been a tremendously negative impact on morale in my office in the last several years for various factors. The pay freezes, as healthcare, as other costs have gone up. I think, when we were going through sequestration and things like that, and people were using terms of essential and non-essential, I think there's nothing more morale, reducing than somehow being told or walking around thinking, well, why am I non-essential? I mean, I think that it's been very tough, quite frankly, to be a federal employee. It's certainly been tough to be. It's been a tough atmosphere for a lot of people, but I think that morale in my office has suffered. They wondered if they had to be furloughed. I mean, they've been living under a cloud, I think, for a long time, and it's been difficult. I will say, but I do want to say this because I think it's only fair. I am every day just thrilled and really pleased by the dedication of the public servants. I think, they still love their job, which is great, and they're very dedicated. And I think it would be wrong for me to not note that. So.
Yeah, I've been on 20 months, and in that 20 months, there have been the threats of furloughs, pay freezes, the shutdown, et cetera. So it's impacted morale. We've had to restrict travel and training. Employees who want to advance can't get trained. But I will say something else that they very much appreciate is the support of this committee, the other oversight committees, because they care so much about the work they do. And I can't tell you how important it is when they know some of their work is being considered by the committees, by Congress. The document issues I've talked about, I'm guessing IG Buller would say the same thing. There is nothing more morale debilitating than folks who want to do their job and have to spend 6 months ultimately getting it, but going through everything they go through, having to elevate it to me, so I have to elevate it to the Attorney General or in a component head. That's another part, I think, of the morale issue. But what's happened the last 20 months, I agree with you completely, Mr. Cummings, Congressman Cummings. It's been a significant morale issue.
If I could just weigh in on the last part of what Mr. Horowitz said. What we've experienced with our access issue with the General Counsel's office has really been very deflating as far as morale goes. What appears to us is that we are being somewhat singled out to be denied access to information that we are entitled to, and it makes my staff feel that they aren't being considered as professionals.
Thank you. I think that's good information for us to know for both causes of morale. Ms. Kelly, I would note for the record that in the omnibus, this committee was instrumental in ensuring that there's now anti-shutdown provision for the District of Columbia, and I have a meeting with the ranking member tomorrow, and one of the topics is modernizing the very act of what happens if we go to a period without funding government-wide. And since this committee has government-wide jurisdiction, it will be a topic for legislation by this committee. So I look forward to working with the gentlelady on that. With that, we go to the gentleman from Arizona, Mr. Gosar.
Thank you, Mr. Chairman. Thank you for all that you do, and we certainly appreciate it. Being from the private sector, I also see kind of looking at this analogy of a car getting stuck in the mud. You have to look at all the principles, the ground, the water, the tire, the surface, all those types of aspects. And it's the conduct and the bureaucrat's mindset that bothers me, because there's not consequences. Unlike private sector, I was a dentist, so I do a procedure. I'm responsible for that procedure for so long of a period of time. But it seems to be here in this nightmare on the Hill that there is no consequences. So I'd be very interested into you as to how do we look at that accountability for time served, having access during that time served, whether it's just in one agency or another, but having jurisdiction within that. Would redefining that application help us, Ms. Gustafson?
I think that in order for there to be consequences and accountability, I think the key thing for us as Inspectors General is that we always have a good dialogue with Congress, and that we're always able, as Mr. Horowitz just noted, to come up here and talk about our work, because quite frankly, I think one of the frustrations, though an understandable one for us, is we can't make anybody do anything, which is to say, because we do not have a programmatic function. What I have found in my 4 years here is the quickest or the easiest way, and it's not easy to make them do something, is make sure that Congress knows what's really concerning you, because they fear and listen to Congress a lot more than they may listen to us, but I think they fear Congress more, and I think that is one of the things that is key. Like I said, I think it's natural that given our role, we're not supposed to run things. I think it is a source of frustration, but I think that's why it's so important and why we have that dual reporting responsibility, both to the agency and to Congress, so that we can kind of have that partnership.
And I understand, but I think that if there's more of a caveat of that there's a responsibility or there is a resultant application that's very similar to private sector, I think you're going to have a lot more application, people saying, listen, I can't stray because there are consequences for my behavior. And I think that benefits us all the way across the board, because it's not just the application of you and Congress, but also what are the damages should I stray outside those lines. Would you agree, Mr. Horowitz?
Yeah, I agree, and I think the issue that I've highlighted that's unique to my office on accountability relates to our ability to oversee potential misconduct by attorneys in the course of their work. Again, that was something that was found by the GAO back to Chairman Brooks and Judiciary Committee back in 1994, that a key part of accountability is transparency, of understanding that there was an independent oversight of the decision, and that the facts were laid out in a fair, thorough way by an independent overseer in those appropriate cases where we should be doing that work.
So, I mean, you bring into another aspect. I mean, you know, when we have complicated cases in the medical world, we have like a case manager. And it seems to me that we could have somebody that's overseeing both investigations and coordinating it. It seems like that would streamline the process. Does that make sense to you?
Yeah, and frankly, that's in some respects what we have now in place with FBI, DEA, ATF, Marshal Service. They still have they still have their own internal affairs bureaus. Right. It simply comes to us in the first instance, so that for what isn't routine, what is significant misconduct, what involves high-level misconduct, we can do. We only have 400+ employees. I can't do every case. The FBI has far more employees, as do the others. It's having that ability for us to look first, pick the cases and take those cases where the public, the Congress would expect independent oversight.
Well, you're just highlighting, you're just on a roll here. You just tied back into where I was going and talking about whistleblowers, because I think very, very important aspect is protections of whistleblowers coming forward in those regards. And so I wanted to ask you a number of questions in regards. So are you aware of any instances in which a DOJ employee was alleged that his or her security clearances were revoked or denied in retaliation for a protected disclosure?
I am actually aware of one recent allegation we received about that issue. I'm not sure that, given only 20 months on the job, I'm not sure if there have been any others preceding me.
And your office does have the authority to investigate these types of claims?
If it's an FBI employee or a former FBI employee, we have jurisdiction over FBI employees and whistleblowers in terms of retaliation. So other department employees we do not have jurisdiction over. That would go to the Office of Special
And so in reviewing cases like that from the limited time that you've been in, has any whistleblower ever had that reprisal and had their privileges revoked?
We have received that allegation.
You're still in?
But we have not concluded that that was the case in that instance that I'm aware of. We have in two other instances, not dealing with those facts, but in two other instances, recently issued reports where we found retaliation unrelated to the clearance issue, but concerned about whistleblowers.
Yeah, and if those allegations were to be true, what would your office be prepared to do?
So what we do is we issue a report to the department's Office of Oversight that then has to handle them, as well as send it to the component for their follow-up on our report and findings, much like we did in Fast and Furious, where we sent the report to ATF and the department and said, here are the problems, here are our recommendations, now tell us what you're doing.
From your insight, Stellard, all the way through law, do you think that there's more applications to protections of whistleblowers that need to be enumerated by Congress?
Let me think a little further about that, given I'm only 20 months on the job. I know that's coming up now on 2 years, but I'd want a little bit more time to think about whether there are issues that I haven't seen yet that some of the folks on my staff who do these cases routinely would suggest.
I would like that. And my previous question in regards to, you know, consequences for actions from employees within the agencies, making sure that, I mean, we've seen it over and over again. When I go back home, everybody says, well, hey, Congress and the agencies are held to a whole different standard than we in the private sector. You get away with murder, is what they'll say, versus what we do in the private sector. And I do agree with them into that aspect. So I would love all of your aspects and protections for whistleblowers, and then also consequences for the actions of employees. So thank you very much.
Would the gentleman yield? Just one quick question. You mentioned FBI retirees. You ordinarily do not have the ability to deal with retirees. What's different about that?
Correct. I'm sorry. If an FBI retiree reported that while they were at work, they were retaliated against, we would...
Or you would protect them, but you couldn't call a fellow retiree
Correct.
who, let's say,
Correct.
Let me just briefly, if Ms. Spear will give me 30 seconds. If we gave you at least the ability that DOD has, which is a uniformed individual can be recalled from retirement in order to continue an investigation. If we gave you a similar authority government-wide that retiring did not allow somebody to evade a IG investigation for the conduct or activities during their tenure, if we gave you that limited change in the IG Act so that the entire workforce would be available to you if they left through retirement, I'm not even saying left without a retirement, but left through retirement, would that be helpful in many of your investigations of senior staff?
It would, it doesn't necessarily even need to be senior staff, frankly. I've seen it across the board in 20 months in several investigations where that would be helpful.
Thank you. Ms. Spear.
Mr. Chairman, thank you to each of you. Thank you for your service to the taxpayers of this country. Ms. Bueller, you referenced that the sexual assault complaints that are filed are restrictive. Yes. And I think it's very important for us to appreciate that even in the Department of Defense, you can file an unrestricted report or a restricted report. When you file a restricted report, the assailant is never investigated. And it's like allowing a sexual predator to continue to prey on other victims. That's something we can fix, is it not?
If you choose to do so with legislation, the problem that we have with the Kate Pusey Act, it's legislatively mandated. That's not exactly what we're talking about or what I'm advocating or what my problem is. We do understand that victims of sexual assault are very traumatized, and that
I understand your perspective. I want the committee to appreciate that right now only restrictive reports are allowed within the Peace Corps, which prevents any kind of action being taken against the predator. Is that correct?
It's not that that's only what's allowed. That's the default. Instead of having a system where a volunteer who's a victim of sexual assault comes in and says, I'm going to make a report, and have that be unrestricted, it automatically goes to restricted.
All right. Let me ask you, Ms. Gustafson, the Alaska Native Corporation and the preferences in the 8A program have been extensively looked at for abuse and mismanagement. Do you have all the authority you need and have all the recommendations and have all the recommendations you have given over the years been implemented?
As you note, ANCs are 8As, and we do have all the authority that I believe we need to oversee the 8A program and to oversee any participants. I would like to get back with you. Right, we've done extensive work in the 8A area. I know that there have been some regulatory changes that SBA has made. What I'd like to do is I can get back with you and with a list of where the recommendations are, because like every IG, we track our recommendations and whether they've been implemented and agreed with. So I'd be happy to get back with you on any open and pending recommendations.
All right. Also, the goals for women-owned small businesses are pitiful in terms of the various agencies actually meeting those goals. Do you have any recommendations, and you can do this by letter if you want, as to how we can somehow meet those goals as opposed to just having them mean nothing?
I'd be happy to get back with you. As you know, the Women-Owned Small Business is a newer program, and the goals are newer. So I would be happy for us to take that back and maybe get back with you on maybe some comparisons and see if there are tools that the other programs have that might be useful. I'd be happy to.
The CRS is working on a report right now on the independence and effectiveness of the Inspector General's agencies, and they're particularly focused on this peer review system. And as I understand it, the peer review is one that is self-review, and it's peer review of each other, of IGs of similar size. And there's some concern that there may be a cozy relationship that is created, and you scratch my back, I scratch yours, or I won't challenge or criticize you and you won't criticize me. Charles Edwards, the acting deputy DHS IG until he resigned in December, was accused of misusing agency money for personal travel, including having his staff drive him around and his wife for personal errands and scheduling site visits in Florida so he could attend his PhD classes, helping his wife get a job as a supervisory auditor within his office, and retaliating against an employee that attempted to call attention to his misconduct, and offering bonuses to employees that helped him with his PhD. An anonymous whistleblower also focused on the former IG for the Library of Congress, who alleged to have verified his own timesheets and claimed credit hours to accrue more than 800 hours in annual leave that he would be compensated for upon his retirement on January 3rd. He engaged in nepotism to hire family friends for positions in the office and used taxpayer money for accounting degrees of family friends instead of hiring qualified personnel. House Administration minority staff told our office in December that these allegations are factors that contributed to his retirement. So how do we make sure that the IGs are on the straight and narrow?
I think, just to clarify, I think we are talking about two different things. Peer reviews are done in IG offices, much like in audit offices, which is where every 3 years an IG will peer review the other to see if standards are being met. In auditing standards, we also go through peer reviews of investigative divisions. You're talking about allegations of misconduct by an inspector general, and so I want to focus on that, which is the duty of the Integrity Committee of SIGI that are charged with investigating those allegations. As I noted before, that committee existed before the IG Reform Act of 2008, but was codified in the IG Reform Act of 2008. And as you noted, under that process, should the allegations warrant investigation by a determination of the committee, another inspector's general office would undertake that investigation. And so some of the things you mentioned, like Mr. Edwards, he would be investigated by another IG that would have the resources and the time to investigate him. I will tell you again that this is the way it's been done. And is often a question, who watches the watchdogs? I think that, quite frankly, we're very proud of the work of the Integrity Committee. I think that in general, I think it is found to do good work. If CRS is looking at it, I think that's happy. We're happy to work with the committee. There are sometimes concerns about the Integrity Committee, and we're certainly happy. As a member of the Executive Council, we often have that dialogue. But I think that the best answer is that's kind of the best we've come up with. Now, obviously, if there's specific allegations, sometimes special counsel will investigate an IG. But as far as investigations of misconduct, I believe that in general, IGs are best positioned to do those investigations because those are the type of investigations that we do. We investigate professional misconduct. And so it's a system that was set up by Congress. I think it's a system that we're supportive of, but we're always happy to discuss it if there are.
Thank you. And Ms. Spear, I might note that in the IG reform bill that's being worked on now, two of the areas that I think address this concern, we're codifying further the 7-day rule and when Congress gets notified, particularly this committee. We're also including the very question of integrity as a required report. Any allegation of an integrity violation by a principal IG has to be reported to this committee as soon as known, not on a disclosure basis, but on a confidential basis, because essentially this committee oversees IGs, and if there's a question of any of the 72, it's critical that that this committee be aware of it. But we'd look forward to your input in these other areas you discussed.
Thank you.
Thank you. The gentleman from Tennessee, Mr. Duncan.
Well, thank you, Mr. Chairman. First of all, I want to say I really appreciate the work of the inspectors general overall. They are especially helpful to this committee, and in fact, I've introduced a bill several years ago to create an inspector general for the Tennessee Valley Authority, and that was passed, and I'm glad we have that in effect. I know the inspectors general sometimes are not the most popular people in their departments, but I appreciate the work that's done, and I especially appreciate the recent work we've had we've had done by the Inspector General for Iraq, who's been in front of us recently several times. But Mr. Horowitz, I am interested in this. About 20 years ago, Forbes magazine had a cover article, and it says, "Time to slim down. Since 1980, the Justice Department has nearly doubled in size to 98,000 and quadrupled in budget to 11 billion. And now the budget of the Justice Department is 250% higher than it was then, an average increase of 12% a year." And the point of that article was that there were so many lawyers at the Department of Justice, and they were falling all over themselves trying to come up with cases to prosecute. And that many people, Forbes said many business people, were being prosecuted for violating laws that they didn't even know were in existence. Now, I know that everybody has violated probably several federal laws unknowingly, and an innocent mistake is not supposed to be criminal, but a zealous prosecutor can make even an innocent mistake seem criminal. And I remember the celebrated case of Ray Donovan, who was in President Reagan's cabinet, and after he was acquitted, he said, "Where do I go to get back my reputation?" The power of prosecution is a dangerous and powerful power. You know, I'm concerned about this, and then I remember Senator Stevens, you know, and the misconduct that came out later by some of those prosecutors, and so I'm a little concerned or confused about what your power is in that regard to do something if some prosecutor has abused his discretion. I was a criminal court judge for 7.5 years before I came to Congress trying the felony criminal cases. Mm-hmm. Most criminal court judges almost all come out of our former prosecutors. I happen to be one of the unusual ones who came from having done criminal defense work. But it seems to me at times that that the Justice Department is almost out of control. And if you see that, what can you do about it?
The way the jurisdiction currently works, Congressman, if there is an allegation about a prosecutor's exercise of their prosecutorial authority, right, that goes to the Office of Professional Responsibility. So the OPR handled the Stevens matter and the referral there, and handled the New Orleans matter recently involving the blogging that made the press. That I've been asked whether I would have the authority to look at that. That was referred to the Office of Professional Responsibility because it involved conduct by the prosecutor in the course of their prosecuting the case. I've been in AUSA. I was for 10 years before coming back to the Department of Defense lawyer, and so I fully appreciate the concerns you express about the power prosecutors have and the need to make sure that that is carefully overseen.
What did you say? Did I hear you say a few minutes ago that, or an hour ago or so, that you are the only Inspector General that is limited in that respect?
That's my understanding, that the IG Act, only that provision, which is an 80, which is specific to my office, my understanding is the other IGs do not have that limitation.
Do you think that restriction should be eliminated or limited in some way?
I do. There's been bipartisan efforts to do that over the years.
But the Justice Department is able to stop that from happening.
It has not gone through in the past, and Congressman Cooper actually was one of the individuals in 2008 who pushed that issue, as we talked about earlier.
All right. Thank you very much.
Thank you. We now go to the gentlelady, Ms. Grisham. I believe by agreement, Mr. Davis, is that correct? That's what I was told. Ms. Grisham.
All right. Thank you very much, Mr. Chairman, and I certainly thank the gentleman. I want to thank the panelists for their endurance and being here the whole period of time. Ms. Gustafson, you mentioned in your testimony that the CIGIE would like Congress to add an exemption to the Freedom of Information Act to protect work papers and other information developed by inspector generals in evaluating the security of agency information systems. Agencies previously used Exemption 2 of the Freedom of Information Act to protect this information. However, under the Supreme Court's decision in Milner versus Department of the Navy, agencies' broad use of Exemption 2 has been limited. CIGIE has proposed exemption from FOIA of information that, I quote, could reasonably be expected to lead to or result in unauthorized access, use, disclosure, disruption, modification, or destruction of an agency's information system or the information that system controls, processes, stores, or transmits. You characterize this proposal as a narrow exemption. I'm not so sure how narrow this is. And I'd like, however, to hear more from you exactly what type of information you believe should be protected that is not already protected under FOIA. Could you explain in more detail what kind of information you're concerned about protecting from public disclosure and why disclosure of this information would be of some concern?
Yes, Representative Davis. What the IG community is most concerned about are the FISMA audits and other audits and evaluations and reviews we do of information technology, information security systems of our agencies. This is something that is mandated, of course, by Congress, understandably so, that we go and make sure that the IT systems are as secure as they can possibly be. Traditionally, IG offices, as you know, all our reports are public under law, which makes sense. We work for the taxpayers, and so our reports are publicly posted. What had been done previous to the Milner decision was, were there anything in those reports that could reasonably be used by somebody with much more IT knowledge than I to perhaps use a vulnerability to perhaps inflict some damage on an IT system? That would be redacted under the High 2 exemption, which under Milner, which was a pretty sweeping decision, a lot of those exemptions went away because I believe the Supreme Court said that that was being interpreted too broadly. So we as a community are seeking to achieve a balance between the public's right, of course, to know our work, and we want our public to know the work, and our ability to withhold information that could be used to basically exploit our systems. This is something we're working with. We have a subgroup of the Information Technology Committees and the Legislation Committee. We work very closely with the committees in Congress that are working on these IT legislation. We appreciate very much that our input is being used. And I will let you know, sir, that we do also work with those non-governmental organizations that are very sincere and very strong in supporting openness in government. And we've worked with those, and we will continue to work with those organizations, POGO, the Sunshine Foundation, things like that. And we're trying to achieve this balance, and we're hoping that we can reach a balance where this information can be protected, and yet our reports remain open, and we're not withholding unnecessarily information from the public.
Well, as the public becomes more information savvy,
Right.
and there's pursuit of more transparency.
Right.
How are those discussions going in terms of working with these entities
Right.
and at the same time being certain, or as certain as you can be, that you are protecting the integrity of the systems?
Well, again, these are very robust discussions that we're having where we're trying to always answer the question of is this information that literally could be utilized, could be a roadmap for somebody to exploit a vulnerability in a system. It's not that we want all of our work to be protected such that the taxpayer doesn't realize perhaps, SBA has an issue with, with FISMA. We think that there are certain things the public needs and should know about whether we are protecting our information. We simply want to, protecting our information technology systems, we simply don't want to be giving the bad guys information they can use against us. And that's really what we're trying to do.
Thank you very much, and Mr. Chairman, I yield back.
I thank the gentleman, and I share with the gentleman and the IG the concern for that. We now go to the gentleman from Michigan, Mr. Wahlberg.
Thank you, Mr. Chairman, and thanks to the panel before joining this committee. I must admit I did not have the respect or appreciation for what IGs and your staff do, and communicate our appreciation for the very important service you provide to this committee and other committees. Mr. Horowitz, let me ask you, knowing the fact that probably a singularly most important function ultimately in your service and your agency's service is to issue a report, what is the thumbnail process for the OIG in issuing reports?
Well, the first thing we do, obviously, is hopefully gather all the documents we need and the evidence we need to assess the facts and the issues. We then internally write up our report, whether it's an audit or a review, such as Fast and Furious. We send drafts, we talk internally, we finalize our report. In some instances for audits, we will report back our mid-audit findings to the component, in part so they can take corrective action sooner rather than later. But for example, in Fast and Furious, we did our draft report, and we then sent it for official comment to the department. We would do the same if it was a component. We would send an audit for comment. The component would give us, in some instances, again, in the audit setting, we will sit down informally with the department, the component, to get their feedback, our auditors, their auditors, et cetera. We may or may not make changes to our working draft at that point, but we will make those decisions. No one else will. It will be an IG decision.
Does that include the timing of your release? It's completely up to you?
Correct. In our office, certainly, I won't speak for all the IGs, but certainly in our office, our practice is we make the decisions on when to release it and how to release it.
What's the appropriate relationship between the Inspector General's office and the DOJ in this case?
Well, on that issue, we would and have traditionally provided the department 1 day in advance the report that we're issuing publicly, and then we will, on our own, through our mechanism, release it publicly. But it's not given to the department for them to release until we've actually released it. We're the ones who control release.
So you consult with them regularly before release. At least that's the normal process. You would consult with the Office of Legal Counsel.
We would not consult with the Office of Legal Counsel necessarily. What we would do is consult. We would interact with, consult, I'm not sure is necessarily what we would do, but we would certainly interact with the component we're overseeing, whether that's ATF, the FBI, a U.S. Attorney's Office, about what we're, in an audit in particular, about what we're finding if there's a problem. So they can take corrective action as we're finishing our report and reporting on the problems we found.
And it's possible then for them, in working with you, to alter the language of the report, the content of the report?
The component or the department can certainly give us their comments about what we've written and what we are intending to say. We will certainly consider that, but we will be making those decisions. There will not be joint editing, writing, anything like that. That is a core function of our independence, is we are the deciding officials as to what goes in that report.
Okay, okay. You referenced Fast and Furious. You gave a report and set down some recommendations in that report. In your opinion, has the the department made progress in implementing the language of that report, the expressed concerns of that report?
The department has reported to us that they have, and we've now initiated, and we alerted the committee that we were initiating a month or two or so ago, the one-year follow-up of our report so that we can report to you and the public how the department and the ATF has done.
Thus far, are you satisfied with the department's efforts in responding to that report?
You know, Congressman, until we finish our reviews, we make no judgments. We want the facts. We'll sit down with my staff, and we'll come up with our views after hearing from everybody. We want to make sure we've got all the...
Have they responded appropriately? And I guess I would say that their efforts in response, has it been appropriate in time?
Yeah, so far we have gotten the materials we've asked for, but we are in the beginning stages, the first several weeks of that review. So we're hopeful that that will continue.
Thank you.
Thank you. Ms. Grissom?
Thank you, Mr. Chairman, and I want to join my colleagues in expressing my appreciation for the roles of Inspector Generals across government. And in fact, in my district and in my state, New Mexico, both fortunately and unfortunately, we've had experiences with the Department of Justice protecting individuals from government abuses and practices, and currently have an ongoing investigation with the largest city in my district, the Albuquerque Police Department. So recognizing that we have that independence, that we can make those complaints and reports, and that I recognize the value and the importance of that work, and in fact, it really is life or death in many of the programs and services that we're providing when it's dealing with law enforcement or medical services provided by a government agency or entity. So I want to thank you for that independent and crucial and critical work. I want to follow up on something that my colleague, Mr. Davis, was talking about in striking the balance between being transparent and meeting our requests under FOIA, but also making sure that we don't enhance a bad actor's ability to either continue on that path or to prevent us from finding additional information. Has there ever been a circumstance where publicly disclosed IT vulnerabilities helped hackers further compromise an agency's IT system since the 2011 Supreme Court case? I mean, to the best of your knowledge, does anybody have any information that that's occurred or was likely to occur or the threat was there?
To the best of my knowledge, I'm not aware of any. I will tell you that I think that the nature of the public reports have changed, which is to say, I think that what is being publicly released has changed because we can no longer black out things and that we would have done that would have exposed a security vulnerability. So the work is still being done. I think the nature of the product has changed, and that there is just a real concern that should there be a legal challenge or something, again, there is a fear of work papers and things like that under FOIA. We really think FOIA needs to be strengthened to protect those papers. It's been fairly recent, it hasn't happened yet, but I know that there is a very serious concern, especially among the IT auditors. We have a very robust IT committee, and again, people who know this IT stuff much better than I, and I know that they have changed, again, the nature of the public reports while they do the work. So,
Anyone else have any comments about them? I mean, it's really a very delicate balance, because part of providing sometimes the folks who are responsible, I'll go back to the Department of Justice issues, have no idea that they have the kind of problems that the Department of Justice is able to identify and find. And when you see those public reports with patterns and practices that can identify for you a much better path to provide the best possible service and care, I appreciate having those be public, and I think it's important for the public to know what the risks are for many of these kinds of services and issues. But you certainly don't want to promote. But I do worry that sometimes we identify concerns that have not factual validity. There are so many things that go wrong, despite our best efforts, that I think sometimes we have a tendency not to be proactive and to retreat. And I want to be very careful. And I appreciate that your response to Mr. Davis and the committee is that you're mindful, you're concerned, you want to do everything that you can to be as transparent as you can for a variety of reasons, not the least of which is to make sure that we know what's going on and we're clear about the problems that you're finding and identifying. And then this body can do something about that if it requires legislative action or there's something that we can do to be proactive. But when you're concerned, we don't want you to retreat from those actions. Is there a group that's working on a kind of a best practice? Is there a way to get additional information back to the committee so that we have a sense about what we could do to aid you in making those final decisions?
Again, we both have an IT committee of SIGI itself, much like the legislation committee. And again, there's also even a subgroup and it's the IT committee, the audit committee, and the legislation committee. We have both of those groups up and running, and we've had dialogue. So we're happy to continue that dialogue and have some new dialogue. There's definitely groups that we can have.
I certainly appreciate your concern because we see the issue, as you indicated, when we're doing oversight of the department and its components, we frequently get the first markings back on classification, on law enforcement sensitive, on other issues, which is, in our view, overclassified or overmarked because the first reaction of those involved, and that their motives are not improper, but it's concern over protecting information. And we are always sensitive about that, and we need to be particularly sensitive when we're asking the committee to do something like this.
If I might, because I'm out of time, Mr. Chairman, I would really appreciate if, as you identify where you're headed and what some of those ideas are, to provide that information back to the committee. And also, you know, we have I've just experienced in New Mexico the executive audited behavioral health entities that are receiving Medicaid found that 100% of them were engaged in fraudulent activity in terms of their billing and service practices. All contracts were canceled. The reports then are redacted, go to the Attorney General. Attorney General can't provide any of that information. And as that battle about, is it really 100%? Are patients getting is there continuity of care? All the things that you have to figure out. You know, we're peeling away layers that identify that we don't have all the facts. It's similar to the things that this committee often finds. We don't have all the facts, that the stuff that was redacted not to protect information to further the investigation or prevent other problems, but rather that it wasn't clear what the issues were, and so it minimizes your ability to make such a broad decision. So I'm particularly concerned and appreciate that follow-up and response. Thank you for your indulgence, Mr. Chairman.
No, absolutely, and I share with the gentlelady the various unclassified classifications, the sensitive but unclassified and redacted. My favorite is the one that they never actually say, which is redacted for embarrassment, which often is the case on some of them. In closing, I'm just going to share something that occurred to me as you were talking, Ms. Gustafson. The fact is that as we look through the MITRE documents and others related to the healthcare.gov, and we discovered that there were vulnerabilities, actual vulnerabilities on launch date. They were not mitigated on launch date, and some of them were not mitigated, and some may still not be mitigated, mitigating meaning fixed. We have that concern that the actual flaws should not be ever made public until they're fully mitigated. One of the great questions, of course, is can they continue to not make public what they mitigated after they've mitigated it? And I think that's an area of concern where if, in fact, IGs clearly do unredact, if you will, at the point that something has been assured to have been fully mitigated, it literally creates the roadmap for the hacker in which the road you have been assured has been blocked. If it has not been blocked, then let's be honest, the hacker is almost a service in that situation, in that if somebody says it's been blocked, then they ought to be willing to say this was a problem and we fixed it, to the extent that there are not other similar problems known but not yet mitigated. Having said all of that, you have an absolute need to know that so that, in fact, you can have the oversight for whether or not the mitigation occurs, whether or not it can then be made publicly available. And we will look to work with the IG community to ensure that FOIA continues to be as open and transparent as possible, but does not create access to hackers as a result of disclosure. And I think that of all the things that we could end on, the recognition that that's an area in which the court has challenged our intent in a way in which I believe FOIA could be opened up slightly in order to clarify that. I want to thank all of you. You heard a lot of things we intend to do, particularly I think when it comes to how we would provide a pathway to testimonial subpoena, cross-agency access, and access to people who have left the Federal workforce. All of those issues are issues that Mr. Cummings and I will pick up tomorrow, but they will not be completely resolved tomorrow. So we will look not only forward to your input, but those 72 briefs that I mentioned. And I'm actually welcoming that, because if people have a private resistance, but in fact it's a resistance from being accused of having asked for a power and thus look bad, then they need not brief. And if they have a real concern and they want to express it, we want to hear that concern so that when we orchestrate a fix, that it is consistent with any real concerns, rather than simply the concern that I don't want to be the one that asks for more authority, which I think, at least in some cases, is probably the case. So again, I want to thank you for your patience, and from all of us on the dais, this committee is adjourned.